Good afternoon, everyone. Thank you so much for being here. My name is Kelly Beard, Content Specialist for Maryland Realtors. I want to welcome you all to our session wrap-up webinar. Today, we have with us CEO Chuck Caskey, Director of Advocacy and Public Policy, Lisa May, and partner with Rifkin Firm in Annapolis, Bill Castelli. Together, they will dive into the 2025 legislative session results and what they mean for our real estate industry. We do encourage your questions, and we look forward to answering them. Please post all your questions in the bottom of your screen in the Q&A box. And with that, I will turn it over to Lisa.
Kelly, thank you so much. And thank you to everyone for taking a rainy, although it looks like the sun might be coming out, afternoon here to spend with us to talk about the good, the bad, and the ugly of what was the 2025 General Assembly session. I know that in our advertisements for this, we had Kristen McGee, our grassroots advocate, here on the lineup. She is flying the realtor flag for us at an event in Baltimore today. But never fear, we have CEO Chuck Caskey with us also to chime in and to talk all things Maryland Realtors, along with our favorite contract lobbyists, number one in your programs, number one in your hearts, our sacrificial landlord-tenant lamb, Bill Castelli, who's here to talk about the always interesting lineup of property management bills that we see year in and year out in the General Assembly session. Before we dive into the specifics, I thought we'd just take a minute to really talk about the dynamics of this session. I am sure it is of no surprise to any of you that this was a big budget year in the General Assembly, and that really changed things, the operation of the committees and of the General Assembly itself. There were limits on the number of bills that could be introduced because the committees knew they would be spending a whole lot of time on the budget. It also meant that fiscal notes and fiscal impacts of bills were far more relevant to the discussions of those issues on the merits. We saw a number of bills get pulled right before their public hearings because those fiscal notes came back at an amount that they didn't think would be viable. If it cost the state too much money, we just put it in a drawer to wait for later. So Chuck Bell, I don't know if you wanted to share any of your impressions of the session before we dive into specifics, but that was the biggest thing that I noticed this year in terms of what our legislators were dealing with. Chuck, anything to add first?
No, I want to hear from Bill first.
Don't we all?
Yeah.
So, in the 25 plus years I've been doing this in Annapolis, I can say this was the toughest session I've had. We've had fiscal problems in the state before. We've had big education programs in the state before. Before the current education funding program, we had Thornton funding, which was another additional $1 billion that the state had to find. But there were a lot of things that hit this session that were unexpected. The expected things were, and things that had been in control of the legislature in terms of funding stuff, like the education funding plans that they approved, the rehiring of state employees, and those were big enough fiscal challenges. But then you add what was going on at the federal level in terms of firing of federal employees, which is a write down on income taxes in the state, as well as just cutbacks on, projected federal funding that some of the state programs received. In fact, clawing back of some of the federal funding that had already been allocated to them. So there were a lot of fiscal challenges, and that drove all the things that you were just talking about, Lisa. And honestly, it's going to continue to drive problems into the future, just because while those things will continue, and while some of the things have been right set in terms of the budget policy, or at least, right set is probably the wrong word, but in terms of them just trying to figure out how to pay for everything, There are going to be, I think, more challenges, and we'll have to see what happens with the economy because Maryland's economy still is lagging other states right now in terms of generating revenue. So those are all things that are going to continue to press and may even result in a special session in October to further address these issues.
Right, we might be having a session wrap up part 2 this fall. You never know. Never know. Chuck?
Yeah, I think to Bill's point about Maryland's economy, I think our job moving forward, the fact that, we'll talk about the governor's housing bill that met an untimely end. What I think our next job is, because I feel like we've already made the case and local governments are hearing the case that we need more housing. And we are seeing signs that individual local governments and even MACO is starting to, and MML, starting to understand that they are the problem and they need to be part of the solution. I think what we haven't done in a big enough scale is make the direct link that the comptroller made in her first report, and I hope in the next report, that there is no daylight at all between our housing crisis and our abject failure as a state to have a robust economy. That we lack, we trail almost every state in the country in many metrics of economic growth. And much of that can be just 100% linked to our failure to provide housing for the people that want to live here and move here and live here, because that's where jobs will be. Nobody will open a company, start a company, move a company, expand a company to Maryland until they're satisfied that the people they want to hire can actually afford to live here. And I don't know why we haven't made that. We need to start screaming that from the rooftops. There is no daylight at all between what Bill mentioned as our lack of economic development and our ability to provide housing as an element of our job attraction. And I don't know why. I have no idea. If the governor doesn't ask me for my opinion, but how is it that those two things are not so inextricably linked in everybody's mind that our housing, proposals, which are not groundbreaking, are not just resoundingly received and passed and enacted. It's flabbergasting to me. So yeah, we have our job cut out for us.
Yeah, and Chuck hinted at something that I think we will see, but it may be an important step forward for us, is we are expecting another report from the comptroller to come out this summer, specifically dedicated to our housing shortage and the economic impacts of that. So if that does come to fruition, we think we'll have a whole lot of ammo for us to use and for all of you to use in your local communities to really talk about the importance of housing and how really, to quote our video that we did on this, that Maryland's economy begins at home. So that was the landscape in a nutshell, in a very brief portion of time. And with that landscape, you might say, okay, that's enough for a session. Were realtors going to get any of their other priorities through? And I'll tell you, we had 8, 9 ideas for legislation that we wanted to bring forward. Not all of them were introduced. We had 5 that were introduced. And I am at least happy to say that 4 of them did pass, which is good in a normal session. I think it's very good in a session like this one. And the biggest one of all, one that you've heard us talk about for years, one that we have worked on for years, is the bill on accessory dwelling units, ADUs. This was a bill that we supported several years ago. it went to a state study. The study made its report to the General Assembly, and the General Assembly did pass legislation to require local governments by October 2026 to allow property owners, if they want to construct an ADU on a single-family residential property. That ADU can be attached, it can be detached. You do still have to meet your building code requirements. It doesn't change the underlying zoning of the property. But this is a housing type that is pro-private property rights. It is pro-free market. It creates smaller and more affordable housing options without the need for government subsidies, without the disruption that brand new developments can bring to communities in terms of traffic and stormwater runoff and all of those things. And that's why we as realtors have been all in on this as a housing type that could eventually bring us another, 10, 20, 30,000 housing units spread throughout the state. It's not going to solve our housing problem by any means, but it's a good and positive chunk of the solution. So we were very happy to finally get that bill across the finish line. And we're going to be working very closely with all of your local realtor associations, because your county boards, your county councils, even some of your municipalities may have to craft these ordinances, hold public hearings on them, and work that through their zoning update process. So we can provide a lot of resources to you. Stay tuned for that, because you're going to be hearing a whole lot about this leading up to that October 2026 implementation date for this bill. Another bill that we have worked on for a couple of sessions now, and you'll see it here called assignment of contracts, but in our shorthand, this is quote unquote wholesaling. And we have worked on this issue trying to provide some consumer protections for these types of transactions. Initially, we looked at licensure under the Illinois state model. Ran into some issues with that and implementation with the Department of Labor. Eventually settled on a disclosure requirement, which is currently being used in Arizona and some other states, which essentially says, if you're going to assign a contract, you need to tell the property owner that you might not be purchasing the property. You may be sending that equitable interest to someone else. And if you are assigning a contract to a buyer, you need to tell that buyer that you don't actually own the property. You may not be able to deliver it to them. And if those disclosures are not made to both parties, either one can cancel the contract at any time before settlement. So if you find out that someone who was quote unquote wholesaling was not upfront with you about what they were doing, you can say, you know what, I'm not comfortable moving forward. I want to get out of this. I heard from our president, Cheryl Abrams-Davis, who recently went through a wholesaling transaction, who suggested that it would be great if we could do a consumer flyer on this that really outlines what assignment of contracts are, what your rights are under this bill. We thought that was a great idea. So we will work with our legal team and our Maryland Homeownership website to get this information out to consumers so that they know that they're protected, and also that they know that realtors played a part in providing those protections for them. Third priority of ours is Senate Bill 46. Now, this was one of 8 to 10 bills we saw this session dealing with the issue of squatting. And bills to address squatters had been introduced on and off for the past 5 years. And it always ran into issues with tenant advocates who said, big bad landlords are just going to abuse this to kick out lawful tenants. We don't think that there's a squatting problem at all. That's really, really rare. this is not worthy of legislation. Well, you have probably heard, and our elected officials definitely heard, all of the instances of squatting which occurred within their districts in the past year. And in fact, those of you in the Baltimore area, or those of you who want to go to their website, the Fox station in Baltimore had just had a very recent news series on this about how there are networks online of essentially people who are putting squatters into these vacant properties, whether it's a home that's for sale and vacant, under renovation and vacant, or vacant because you're in between tenants. It's scary, it's infuriating, but fortunately or unfortunately, those examples were proof that no, squatting is a problem in Maryland, and you can't continue to deny it. And our members of the General Assembly said, no, something is going to happen on squatting this year. As most things, this was a compromise. This creates an expedited unlawful detainer process where within 4 days of filing a complaint for squatting, service process is going to occur. And then in no more than 10 business days after the filing of the complaint, the judiciary, the courts are going to hold a hearing on that allegation of squatting. And we understand that 10 business days sounds like a really long time. When someone is trespassing in your property, you want law enforcement to show up and get them out immediately. But what we did hear is that sometimes the individuals in these homes are victims of fraud themselves. Maybe they thought they had a valid lease. They contacted someone on Craigslist, they paid the deposit, they've been paying rent, they think they should be there. And law enforcement, when someone presents a lease to them, they have no idea whether the person should be there or not. And they don't want to be making those findings of facts on someone's front porch. So going to the courts, you know, as we were negotiating, seemed to be the fairest to all of those individuals. But we have heard from the judiciary, they understand their marching orders. They know when squatting is alleged that they should move these cases to the very front of the line. So 10 days, I think, will be the longest period we might see for these cases. It could be much shorter. And then our final priority was a cleanup, a modernization, a streamlining of our continuing education statutes. And this bill did a whole lot of really little things. And in fact, it warranted its own slide, just so that everyone could be really clear on what it did. All right, CE content. In our statutes, there were a lot of things that could create confusion among licensees. Are they taking the right class? Are they not? Are they doing what they need to be doing? You all know that fair housing in statute was 1.5 hours. NAR's new requirement is 2 hours. We didn't want anyone to be caught taking the wrong fair housing class, thinking they were all good when they weren't. So statewide fair housing is going to go to 2 hours if you touch residential transactions. If you're exclusively commercial, you won't take 2 hours of fair housing. You'll take 2 hours of ADA compliance. The other change, for those of you who are brokers, broker supervision is currently 3 hours. And we had heard from instructors, even some course participants, that there is not 3 hours of content there. So broker supervision is going to go from 3 hours down to 1.5. We also have 2 brokerage classes in statute. We have Brad for everybody and Brad SD for those who are brand new licensees within their first 2 years of being in the business in their first license renewal cycle. That was never ever intended, but somehow that's how the statute came to be interpreted. But brokerage laws are the same for everybody. So therefore our brokerage class should be the same for everybody. So there is just going to be Brad. Another provision for those of you who take ethics, and you may have noticed this in your ethics class. A lot of times there would be a slide in the class that says, flipping is legal in Maryland. And you might wonder, why is Why is this slide there? Well, because state law said it needed to be there. Flipping's a legal practice. That's all you needed to say about it. We struck that out. No longer will you have to have, spend that 30, 45, 1 minute section just to say that something is a legal practice in Maryland. That's gone. And then the final provision has to do with how continuing education instructors are selected and approved to teach our classes. This is really inside baseball for our realtor associations and some of our larger brokerages where you teach classes internally. But for those of you who are on the inside, this essentially means that there is no more train the trainer process. It made sense when it started. It had outlived its usefulness. There is now one standard for CE provision in the state and the nuts and bolts on that. So that was a lot, particularly on CE. I'm going to pause and let Chuck and Bill weigh in on our realtor priorities. Also give some of you guys a chance to put some questions in the chat if you would like to, or if you have questions about any of our realtor priority bills.
Let me just start, I guess, here, since we're already here. Excuse me. There was a question, what is BRAD? BRAD is the old agency law, was renamed Brokerage Relationships and Disclosures. So it's agency. SD meant seller disclosure.
Seller disclosure.
So for some reason, the state required seller disclosure disclaimer form got folded into a class on agency. We still not sure how that happened, but it did, and now it's gone. So we fixed that. I want to take it a step further. The last bullet point there, it's not just instructor certification, but it's providing the materials, the handouts, the slides for the agency/BRAD and the broker supervision classes. I can tell you, and I've shared this, so it's I'm not throwing the commission under the bus. They know exactly how we felt about this. The materials that they made us use, the slides, the handouts, were not useful. They were awkward. They were not well put together. And the schools and the instructors are the right places for those to be prepared by the schools that provide these classes. Should be allowed to choose whomever they want to teach these classes. And as Lisa said, agency and supervision, when they became required classes, more than 10 years ago now, Bill? Pretty sure, like about that. Anyway, we understood that. We supported that. And we participated in the development of both of those classes. And the original versions we helped to develop. Then the commission went off, kind of did it on their own without even consulting with us, and we think made a mess, frankly, of those two classes. So the schools hire their instructors. Schools are the ones responsible for making sure the instructors have good materials and are providing good instruction. Evaluating their instructors. And if they're not doing a good job, then they got to find somebody else to teach those classes. But there's nothing inherently, more than 10 years later, there's nothing inherently so different about agency and broker supervision from all the other classes, whether they're required or not. And so all this does is put those two classes in the same posture as all the more than a dozen other classes that people teach. Flipping, I just want to say one more thing about that, is because, having read some of those cases from the illegal flipping, and I do this in fair housing, discrimination is not illegal. Illegal discrimination is illegal, right? We discriminate all the time. And many forms of discrimination, in fact, are not illegal. Most forms of flipping are not illegal. Our members, many of you out there, I'm looking at some of these names, I know for a fact, that a lot of you out there flip homes. It's as part of what you do. And as long as you do it right, it's not illegal. When that was put in the law to require us to teach flipping, they meant illegal flipping. They just didn't say it because at the time we were so worried about the kinds of antics that were really ripping people off. And frankly, and the good news is a lot of those people went to jail and spent significant time in jail for those illegal acts. So flipping, predatory lending, those made sense at the time, but then over time needed to be done better. Okay. The new requirements take effect October 1st, yes?
Yes, actually, all of our Realtor priority bills take effect October 1. Usually the only exceptions to that October 1 effective date are tax provisions and things that really impact the finances of state and local governments. Some of those will have a June or a July effective date, but for most everything else, October 1.
Brenda Small makes a great point and a very good question. When did Maryland housing market and economy begin to slide? Actually, Bill, I'm going to ask you to address Brenda's question. There are significant new developments. Look, I travel and especially in Southern Maryland, Frederick, yeah, parts of Prince George's and Montgomery counties. And I think, Brenda, you answered your own question. They quickly sold out. Of course they did. Starting prices are beyond many entry level and even move up buyers' affordability range. It's not just your opinion, it's a demonstrated fact. So you kind of answered your question, but Bill, you fill in some of the blanks about the relationship between housing and the economy and Maryland's place in the national conversation.
Yeah, I mean, I don't think you can point to like a specific degradation of like the Maryland economy compared to other states. I think it has been anemic for a long time.
Yeah, exactly.
And part of that reason is, part of it's good in that Maryland is very reliant on federal employment. If Michigan used to be and probably still is the car companies, but here it's federal employment that drives so much of the economy. So that's why you've had a write down in income taxes with some of the federal changes this year. And that's been good for a lot of reasons because it drives a lot of related private businesses as well. So contractors with DOD and the federal government. There have been significant changes in some private contractors, even in Baltimore City, that were engaged with USAID and other things. So there's been some loss of employment there. So as the federal government funding, has been cut over the years, that's been part of it. But it's also just trying to compete with the Virginia that's right next door to us. And, they've had a lot of dedicated policies, including tax credits and other incentives to get and drive some of that private business in that state that Maryland has not been as aggressive about. And I think prior administrations, including this administration, have targeted, at least have targeted some businesses like biomedical businesses, things like that. But Maryland just has not had an aggressive program the way some of these other states have.
Yeah, and that's a public policy debate that we can't have today about how much taxpayer dollars should be going into attracting and in effect subsidizing businesses like the Amazon, bidding war.
Right.
We don't have that kind of time. I will please, there are two people with their hands raised. We will not be able to take people's questions. So please put them in the chat. You can lower your hands. We're taking these questions in writing only, please. Thank you so much. So we go back, I don't know, there's a couple still on wholesaling, so to speak. Will we be able to create the disclosures? I'm gonna say absolutely yes. Anytime the state law passes that requires a new written document, a form or disclosure of some kind, our statewide forms committee will be on that. So I'm gonna say yes to that. Does the assignment of contract disclosure show the wholesaler's fee? Lisa, I don't remember. I don't think so.
It does
Yeah.
not.
I didn't think so. Can you solicit a listing with the owner of a contract? So let's just be clear. The short answer is yes, because we are an equitable conversion state. So if I'm the contract purchaser, I have a recognized property interest that I can independently transfer, sell, in effect. Now our contract says it's not signable except with the written permission of all the parties. So my guess is that these people assigning contracts do get the original seller to sign over their ability to assign the contract. That said, there was a question about listing them, and the answer to that is no. So you can broker an equitable interest. Why you would, I'm not going to answer, but clearly the fee is the one way to make money for a contract assignment. The other is to get the original contract at a low enough price so that you can not only charge a fee, but also maybe sell it for a higher price than the original sale price, which has happened, and people have found themselves really victimized and equity stripped from them. The original owner, the first seller, really should have gotten the benefit of whatever that full price is, and sometimes that hasn't happened. So that's one problem that the bill is intending to address. The other issue is in years ago, I guess even before Bright, so MRIS, I think, don't quote me on how long ago it was, but the MLS in Maryland used to accept contracts and equitable interests to be marketed on the MLS. They stopped that practice some years ago. I think it was even before COVID. So that, was one avenue that was available to us if in fact we wanted to market a contract, but the MLS is no longer available. So you don't think there's a legal impediment to us as realtors brokering an equitable interest? My only question is, my caveat is to be careful about that because there are some traps.
And we have a question about someone whose license renews in January and compliance with these new CE requirements. Happy to tell you that the Maryland Real Estate Commission just met yesterday afternoon. They are aware of all of these changes, and they will be putting out guidance for those of you whose licenses are renewing after the October 1 effective date for these bills, to let you know exactly how to navigate all of these changes, what they will accept. And we will certainly pass along that information to all of our members as the Real Estate Commission puts it out. And then check one final question here about equitable interest
Yeah.
and mobile homes on leasehold land. I don't know
Yeah.
if you want to answer that now or if that's more of a
No, I
legal
can.
hotline
I mean,
question.
I can, and actually the questioner answered it themselves because it says no real estate involved. That's the answer, not just the question. That is the answer, because equitable title is an interest in real estate. Mobile homes are personal property and not real property. So that's the answer. The questioner provided the answer, because unless you avail yourselves, the owners, that is, of the law that passed, when that bill passed that was a while ago, where you actually can convert a mobile
Conversion.
home to real property, that merger bill. That
Yeah.
was 6 or 7 years ago. That was before COVID, if I'm not mistaken.
Yes.
You want to go, do you remember like some of the details of that, how you convert that to real property? There
Yeah,
were a
I
couple
mean,
of things you had to do.
yeah, I mean, it was more of a filing requirement, so you had the ability to convert as long as it was on a permanent foundation.
Right. Yeah, and then you got, instead of a vehicle title, you actually got a deed.
Yep.
Yeah, so there is a way to convert personal property, which is a mobile home, to real property. You just gotta follow that law. Yeah. If it's not real estate. Yeah, Doug Rubin, I'm not sure. Call us back on that. Yeah, I don't know, whether we're interested in providing forms for the brokerage of equitable interests. That's a policy question we're gonna have to answer. And I don't know, I can't answer that here today about whether that's something we want to facilitate. I don't know. Yes, there you go. Affidavit of affixation. Thank you, Doug. That's right. I remember now.
All right, well, guess what, guys? That was just our priorities. There's even more to talk about. So we're gonna get moving. To
I
talk
like
about
the
this.
idea of a housing summit. I'm not averse to that at all.
Yeah, actually,
not
we've had
opposed to that.
conversation with the builders about that.
Yeah,
It was something
yeah.
that used to occur. So
Yeah.
yeah, definitely food for thought on that one.
Yeah.
All right, let's get back here. All right, Chuck already alluded to it, but housing supply being another key theme of this session. We had a few kind of smaller wins in addition to ADUs, one being that under House Bill 1193, localities will need to report their permitting data to the Office of Planning at the state and also make that data available for the public to view so that you can see exactly what kind of housing stock is being added or not added in your local community. That is data that can help us in our advocacy efforts for housing. There is also going to be a study under House Bill 489 on single staircase building codes. And that's a very kind of niche thing. But essentially, if you are building mid-rise buildings, currently you need to have 2 staircases or two essentially directions of exit from that. There are cities and states and over in Europe where they have been, along with additional fire safety features, you can have much taller buildings with 1 staircase. That brings down costs and it also helps with adaptive reuse. So Maryland is going to study this and come back with recommendations on how we can adapt our building codes to safely allow single staircase buildings. Now, the bills that did not pass, and we mentioned one, House Bill 503, some of you who attended our session preview or are stuck with us through lobby day knew this as the Housing for Jobs Act. It was then amended, it became the Housing Development Act. It was amended and watered down even more to where within the closing days of the session, it really didn't do anything. It didn't resemble any way that it started out. And this was the administration's housing bill. And they said, you know what? This doesn't look like anything we wanted to do, just never mind. And it died. Which I think is a reminder for all of us that yes, we are making progress on housing, but it's slow and it's in bite-sized pieces and it's not the true sea change of opening up our housing supply faucet that a lot of other states are starting to get right. And somehow we are still very timid and very hesitant to really take the plunge. If you'll forgive all of my, water metaphors that I used on that. Finally, we also did have a bill, House Bill 38, to look at adequate public facilities ordinances. Those are local laws that say we have to time infrastructure with development. On the surface, that sounds amazing, but all too often, those adequate public facilities ordinances are used to delay housing for as long as possible, to add costs, to create uncertainty. And it really is becoming one of the kind of self-inflicted issues and self-inflicted policies that we put on ourselves that have stopped us from getting the housing that we need. I expect that we will, of course, see more on housing next session. We'll be pushing for it. Others will as well. But it's just a reminder that because we've had a couple of breakthroughs, we can't let up. In fact, we have to really focus and drive even harder on the issue of housing supply and push back against, as Chuck said, the local government obstacles that keep getting thrown up in our pathway on this. Next, this is where I turn it over to Bill to talk about everyone's favorite topic, landlord-tenant issues.
Let's just get to the one question.
Oh,
Those two
great.
bills never passed at all. As a matter of fact, as Lisa mentioned on House Bill 503, the governor said, do not pass this. This is not my bill anymore. It was an administration bill, and now it's not. And I think House Bill 38 never even got out of committee. I don't even know if it even got a hearing.
It did get a hearing just
Did it?
because it was House
Okay.
Bill 38 and it was
Okay.
pre-filed and they had to give it a hearing.
Okay, okay.
But it did not move out of committee. That
Didn't get
is
a vote
a
in committee.
very, almost the third rail of development, as you know,
No,
Chuck
I know
and
that.
Bill.
Yeah.
Yeah,
We don't have that kind of time. We're not talking about adequate public facilities today. We'll have a whole nother one on that.
that's right.
Come
That's
to the
right.
conference. We're gonna talk a lot about APFO at our conference.
Yes, exactly. So, Bill, you want to tell us the good and the bad?
Yeah. So I'll start out with good cause eviction, and this is a bill that's passed in a number of states. And basically, what it does is it just says that if you're a landlord and you don't want to renew a lease, you've got to tell the tenant, you've got to provide, the causes for terminating that lease. And it specifies what those causes are. We've always had a problem with this bill. Property managers that we have and owners of rental property, we think both parties sign a lease. The lease has a start date, it has a termination date that both parties agree to. Nobody should be surprised at the fact that a lease, is terminating. Nobody should be surprised at, what options they may or may not have at the end of that, and exploring that and having a conversation with a landlord, especially since in the last few years, Maryland has really made an effort to make sure that tenants are given, even longer notice of when a lease is not going to be renewed. So we think that actually solves 95% of the problem, actually 98% of the problem. But this bill keeps coming back. I personally thought it was going to pass this year. There were changes in the Senate committee that made it, it didn't look like we had the votes to stop the bill this year. I will tell you, the Senate President's office stepped in this year. They kind of gave a very difficult choice to the tenant advocates. The bill had a number of provisions that would make the bill better. It was an enabling bill too, so this would not have been a mandated bill. Local counties would have had the authority and would have had to enact a local bill themselves. But ultimately, what killed it was the fact that tenants walked away this year after the Senate President's office basically said, look, we're okay with doing good cause, but you can't have both a good cause local statute and a rent control statute. So for those counties that have passed rent control, you got to choose one or the other. It's either going to be the rent control statute or the good cause statute. And so the tenant advocates kind of walked away from the bill this year.
Bill, can I just interject real quick? The fact that they are very good, the advocates, and this is not just tenant advocates, it's all advocates, choose their words very carefully and purposefully. And so what Bill said was rent control. They don't call it that. They call it rent stabilization because nobody likes control, but who can object to stabilization, right? We all want stability. So they know the power of the words. Bill slipped in there the word eviction. We are adamantly opposed to using that word because it's not an eviction. It applies to renewal of leases after their agreed upon termination date. The advocates are refused to call it anything but an eviction. So let's be very, very clear. It is not. And that's why Lisa she just put good cause on the slide. And so we will not be using the word eviction because it's not an eviction. The tenant advocates have, adopted it because it sounds good. Of course you need good cause to evict somebody. Of course you do. That's not what this is. And so we have to consistently, constantly be vigilant to not buy into their labeling of things to get that emotional reaction that hurts our ability to advocate one side or the other based just on the labels that people put on things. So that's a real important part of our advocacy is making sure that we call things what they really are. Sorry, Bill. Thank you.
Good point. Late fee legislation. This was more of I would call it a clarification. Maryland law has always permitted a late fee. It always capped it at 5%. This just clarified that the 5% applied to the unpaid portion of rent if some of that rent had actually been paid. So this is more of a clarification bill than anything else. And then the notice of eviction bill. This actually resulted from a Fourth Circuit case, the Todman case, before the federal courts. And in that case, they basically said a tenant's got to have notice of when that eviction day is going to occur. So if you're being evicted for whatever reason, non-payment of rent, breach of lease, then you would need to be provided that date so that you have an opportunity to remove your personal belongings and everything else. So there was it was based on the Baltimore City law. And there was a lot of discussion about what this should look like. But at the end of the day, what they eventually passed was a 6 days before the scheduled date of repossession. A landlord has got to provide that notice to the tenant, telling them what day it's going to occur. It specifies how that notice has got to occur, and then local jurisdictions can actually pass a tougher law with lengthier notice provisions if they want. But all this does is it basically locks in at the state level a 6-day notice period, along with kind of specifics on how that notice is provided.
And Bill, actually, just to chime in here, when this bill was heavily amended through the work of Bill and our other friends in the rental housing space, as this bill was introduced, the property owner was going to have to keep tenant possessions in the unit for 10 days following the eviction, or to store them at the property owner's cost. And that was a bad bill. And it was, through Bill's advocacy and that work that this bill was able to be amended into what it is right now.
Yeah, we use the example of in many cases, especially single family homes, there's almost always personal property left behind, the broken fish tank. So, an extra 10 days, you'd have to babysit the broken fish tank before you would be able to remove the property and get it back into productive use. That didn't make any sense. Notice of entry, that is really shouldn't be much of a practical change for landlords. This just basically said, except in one provision, it basically is if you have to enter into a unit, you've got something to fix, you've got a complaint that you've got to investigate, something like that, you've got to at least provide 24-hour written notice. And then it does limit the timeframes that you can get access to the property. So between 7 a.m. and 7 p.m., you would have the contractor come in to schedule it. This bill was also a much more onerous bill when it was introduced. So there were a bunch of amendments and changes that were made to the bill. In terms of notification, it can include electronic notification or just posting to the door. And it does exempt emergency situations, broken pipe, you've got to get immediate access to that unit regardless of the time of day, things like that. So there are certainly exemptions put into the bill as well. On the bill on pet policies, this is, again, I would say more clarifying. Law already required you to have a pet policy. This basically says what you have to have in terms of the terms of the pet policy, being specific about the breed, the number of pets, things like that. And also that you've got to have that policy available with the application so that a tenant is familiar with it before they sign the application. And if you've got a website as a landlord, then you should have the ability for someone investigating and looking at that website to also pull up your pet policy. And then the mold bill is, again, I would say not much of a change from what currently goes on. It's very specific in terms of there must be a pamphlet that's given out. The state is actually going to put that together. The one thing I will note is that this bill does have a July 1st effective date. So it's a little concerning. We want to make sure that that pamphlet is done in time. So we are watching for that. But this basically says if you've got to make sure that that pamphlet's given out before they sign the lease. And then when a tenant has a mold problem, and this is something they can currently do, and they file a complaint about it, then you've got a certain amount of time, 45 days, to address that complaint. We were able to add a little more flexibility into it so that if you can actually do the work, and in some cases, if it is like a single family home with a significant mold problem, it's probably going to take more than 45 days to do it. So there's some flexibility within the statute to say 45 days or a reasonable amount of time based on the work that's required. And I'll stop there on, did I hit them all? Yep.
I think you did. Now, Bill, we have a question. Is a listing entry in an MLS considered a property website for the pet policy?
No. It would have to be what I think most people would consider the actual website of that. So for a lot of like mom and pops, probably, don't have websites, not going to impact them, but it would be your .com, website.
And a question from our friend Kathleen. Did the mold bill say that landlords could hand out an EPA pamphlet in the interim?
No, it did not specify that. It's not clear what there's another provision in that bill that really directs the state agencies to come up with what that notice is going to look like. It also requires them to do a little bit of work in terms of identifying the types of mold and remediation that's going to be permitted to be done, so that, and that's not going to be the concern of property managers, but once those contractors are hired, that section of the bill is really going to dictate what it is that they're doing and what they're addressing. And they've got to be concerned about what those provisions are.
Great, thank you, Bill. All right, moving on. Oh, another favorite topic for all of our members, condo and HOA. And if I sound like a broken record, I might sound like a broken record, because once again, most bills dealing with condo and HOA oversight did not pass. including House Bill 1211, which it gets into, again, the resale fees and the resale process. All of those complaints that we hear from you year in and year out about that. We're going to keep plugging away before anyone asks. Yes, absolutely. This is something that's going to be on our agenda until we finally are able to break through. The biggest thing I think that would help us if we could just get one session where we get our House committee and our Senate committee to just focus on this one issue in addition to all of the other sometimes even self-admittedly bigger, more important things like public safety or things of that nature. But we're going to keep making the case that really these resale fees are a profit center for these associations. They've admitted as such. And we should not be requiring fees in statute that are really a profit center for these associations. But there is one bit of good news when it comes to condos and HOAs, and that's one that we've heard from all of you about over the years since the requirement that associations conduct reserve studies was put into law. That bill was passed, and for our older associations, the ones that had either not been keeping up on their maintenance or had not been doing reserve studies or fully funding those reserves, this bill created some hardships for them. And we heard special assessments, we heard large increases in dues for members and the monthly dues. And so the past couple of sessions, there have been bills introduced to provide some more flexibility for associations to meet those reserve requirements. And this year, happy to report, House Bill 292 finally did pass. I think that's been at least 2 or 3 years that this bill has been there. And essentially it says that associations have a number of different ways that they can show that they are fully funding their reserves other than having just that amount of cash sitting in an account somewhere. It also gives them longer timeframes to ramp up those reserves. It was 3 years, now it's 5. And it creates a hardship process where an association for up to 1 fiscal year can deviate from the reserve funding plan if something like a natural disaster or a fire occurred or a tree fell on a building and they need to take their funds to address that instead of putting them into reserves. They're able to do that through a vote of their governing body. So again, this one will go into effect October 1. We think that that will help some of those associations that are having difficulties, but still ensure that resident safety is being met, that mortgages, that insurance coverage will still be available in those developments, because those bodies are looking at an association's reserves before deciding to issue a mortgage loan or before deciding to issue an insurance policy, or in some cases even pay the claims on the insurance policy if they know that maintenance is not being maintained there within the development. So that is condo and HOA. I'm going to turn it over to Bill again, just to talk about energy issues, green buildings. That is another topic that is taking up a lot of time and yes, money in our legislative debate.
Yeah, and I'll be pretty quick on these, but the only 2 bills that have passed, the septic bill and the green or the BEPS, which is the Building Energy Performance Standards legislation. So Maryland, about 2 or 3 years ago, passed the Climate Solutions Act now. That included a component in it for buildings of over 35,000 square feet that they've got to meet building energy performance standards. And it became very controversial. They were using energy use intensity standards that became very controversial, expensive, difficult to know how many larger commercial buildings, including many apartment buildings, were going to be able to comply with it. So when the regulations for the Climate Solutions Act now were issued, they had standards that, quite honestly, many within the commercial real estate industry did not think, anybody within the industry would be able to meet it. So they pulled back from the regulation, they introduced this bill, and nobody was happy with this solution, which was going to provide an alternative compliance path. It went through about five different iterations during session. And eventually what they ended up is they exempted certain buildings, critical infrastructure, military, hospitals, and they made an effort to basically say, okay, by the end of 2026, we want to study just on all different alternative compliance paths. And it made it clear that that report has got to be issued before the department can kind of move ahead with the regulations in terms of specifying what those alternative compliance. And when they're thinking about alternative compliance, they're really talking about a lot of these older buildings, older apartment buildings in Baltimore City that, would be very difficult to retrofit and become kind of all electric, or at least not relying on fossil fuels of any kind. So that's the ultimate goal of the bill. So it really kind of moved the most controversial parts of it into a study, and then provided a little extra clarity for some critical infrastructure. The other bills that didn't pass were all different kind of versions, at least the two energy bills were all different versions of more aggressive building energy performance. So it would have created a requirement for all electric in new buildings. And this would have been for all new buildings in some of these cases, or at least they would have had to embrace an electric ready standard, which means that things like electric cars, infrastructure would have to be ready for installation. So you would have had to have a big enough electric system, a place to plug in, things like that, even if you weren't putting those systems in place. So those bills did not pass. And I would say, given the fact that they have not even been able to implement the BEPS standards, I don't think those bills are going to go forward until they've really locked down, compliance issues and cost on the current BEPS standard of over 35,000 square feet. So I think that's kind of where we are at the state. There was Montgomery County that passed a BEPS standard. That is still moving forward. That county has had it since, I think, 2014. So it is still possible that local counties could have a more aggressive BEPS standard, but right now Montgomery County is the only county that has it. And then there was a septic inspection bill that didn't pass. It did pass the House, got to the second of the 3 votes it needed within the Senate, but did not get the third vote. And this would have required septic inspections before you leased housing unit, so detached unit, or actually wasn't even just a detached unit. And then also a required septic inspection for any for sale unit as well. Those provisions were delayed, so they are requiring licensing for septic inspectors. The department has kind of been in the process of trying to get that up and running. So these provisions would have been delayed to 2028. But I do think that bill is going to be back next year, given the fact that, it already did pass the House. And then the final septic bill really is just a reordering of the current grant process. So right now, if you're going to get a septic grant for one of these enhanced nitrogen systems, which are very expensive, it provides a little more clarity in what the order of those requests are. So this one focused on making clear that there are certain properties that are within not just the Chesapeake and Coastal Bay areas, but if you're within what they consider to be a 8-digit watershed, which is a measure that the EPA uses, and you're in violation of that 8-digit watershed in terms of pollution, then you would be moved up the list a little bit. You still would not be moved up past failing systems for the coastal bays and the Chesapeake Bay watersheds. But it does provide a little more clarity that yes, they can get a grant. It's not a preferred grant over the coastal bays and the others, but they can get a grant, assuming that funding is available. All right.
Great.
And that septic grant bill is effective July 1st too.
Thank you, Bill. All right. These are not normally bills that I would bring up in a session recap because they really have to do with mortgages and appraisals and things of that nature. But I did want to spend just a little bit of time on House Bill 1516, which was called the Secondary Market Stability Act. This bill also came out of a court case from 2024 that essentially said that passive trusts that hold mortgages have to be licensed by the State Office of Financial Regulation. You might say, okay, but who cares? What does that have to do with anything? I had to learn what that had to do with things just from this issue. So the Office of Financial Regulations issued that directive in January and said, okay, you know, if you're dealing with passive trusts and mortgages, you have to be licensed. Why does that matter to us? Well, when mortgages are securitized for sale on the secondary market, they are put into passive trusts. And the way this regulation read was anyone who was involved in mortgage securitization was going to have to be licensed by the state of Maryland. And they were going to have to be licensed within about a 2-month period. All of those companies, and I mean, we're talking the big players, Bank of America and JP Morgan and Citibank and Goldman Sachs, and all of them said, whoa, this is a big change. We don't know if we're going to be able to do it. There's liability here. We don't know exactly what the landscape looks like in Maryland. So what we are going to do in our directive, we're not going to buy mortgages anymore in Maryland, which made our mortgage lenders say, should we be issuing mortgages anymore in Maryland if it means we can't sell them, if it means we have to keep them on their books? So without this bill, we were entering the spring selling season without knowing if mortgage financing was going to be available for home buyers. And that's pretty scary. So we thank our partners within the Maryland Mortgage Bankers and Brokers and the Maryland Banking Association for bringing this issue to our attention. We lended our voice to help first get those regulations delayed until this emergency bill, which is effective upon enactment and is in place now, could put a hold on it and say, wait a minute, you don't have to be licensed if you're just holding mortgage capital in a passive trust and not servicing it or doing anything like that. And we're going to study the licensing needs for trusts in the coming year. So that was something that really did help protect our housing market in a kind of unconventional way. And then also Senate Bill 689 has to do with mortgage assumption. This is one to watch. California passed a state bill that said that mortgages, in the cases where a married couple gets divorced and both are named on the mortgage, you could have one spouse or the other assume it under the same terms. What California did was say, yes, that is effective going forward. Maryland's bill actually made it retroactive, and that could be a problem. We may run into some federal preemption issues with this bill. There may be some litigation over it. We don't know exactly how this one's going to play out. We would certainly keep you informed, but something to be aware of when you are helping clients, perhaps sell a home or avoid needing to sell their home in the instance of a life circumstances change. And I see a question up here. I'm going to hold that question on tenant right of first refusal to the end. But now our last topic, and probably the biggest elephant in the room, was the state budget. the all-encompassing thing. But I think to really understand where we ended up in the state budget, you need to go back to last session. Okay, we have a $3 billion budget, shortfall, which we knew of. It grew to about 3.3 billion in the opening days of the session. But last year, the House said, we know we're going to have a $3 billion budget shortfall. Let's go find $3 billion in revenue. And this was one of the ways that they proposed doing it. That infamous sales tax on services. So that was 5% across the board, all professional services, including, yes, you, our mortgage lenders, appraisers, inspectors, every aspect of the housing industry. And last year, we were really able to show, along with our partners, the way that 5% tax added up on something like a home sale or building a new home. That people were going to be paying that 5% over and over and over and over again, and eventually that ended up costing real money. So this year we did see a reintroduction of a services tax, but look at the difference between this year's tax and last year's. 2.5%, but also look at all of the real estate services that were pulled out of it. And I think that was at least, some acknowledgement that, hey, we had a point. If we're worried about housing supply and we're worried about housing affordability, we can't be taxing all of these things that impact that affordability. So this was on the table, along with, as you will see, just a whole host of taxes and fees, and including some things that we really typically hate, right? Property tax increase, transfer tax increase, some of the services taxes that I just mentioned, but also reducing the estate tax cap, eliminating opportunity zones. And those were things that we spoke out against in our comments on the budget. I don't know, and I'm sure Bill will probably shake his head on this. I don't think anyone's happy with the final budget. Anytime you are, adding $1.6 billion in taxes and fees and cutting $2 billion in programs or services, no one's going to be happy. But by and large, I think we can at least be relieved. Because it could have been a whole lot worse for real estate, and for some industries, it actually was much worse than what we experienced here. So what did make it into the final budget? And we'll have a breakdown for this in our session recap article that is coming out in our next magazine. But they did add 2 new income tax brackets for what they termed high income earners. That's for those earning over $500,000 for an individual and $1 million for an individual. So higher income tax brackets. We do know that those of you who are LLCs who claim your business income on your individual tax returns, it is possible for some of you to be caught in these changes to the income tax brackets, and also the changes that are coming to itemization on your income tax returns. For those who are under $200,000 in income, you can still itemize as long as you do on your federal tax return. And they did increase the standard deduction by 20%. But once you get above $200,000, there's going to be a gradual phase out of the itemization that you can claim, going up to $500,000 where you cannot itemize and claim deductions on your individual income tax returns. There is a local option. So at your county level, they are allowed to increase the local income tax from 3.2% to 3.3%. Many of your counties are going through the budget process right now. That might be something that they have discussed or might be moving forward with. And then the 2 kind of services taxes that did get through, which could impact realtors in your day-to-day business, was a 3% tax on IT services, although they did exclude some of those emerging industries like quantum computing and cybersecurity and things of that nature. And then also they accelerated some vehicle fees and taxes, which were enacted last session, increasing the sales tax on vehicles, increasing registration fees. So while the talking point is out there that yes, a lot of Marylanders are getting a tax decrease on your income tax, you might very well be making it up if you own a vehicle, if you run a website, or engage in some other services. Because as we said, there's still $1.6 billion of new revenues that came out of this budget. So Bill, Chuck, I don't know if there's anything that you want to add to the budget. You know, we tried to take a big picture view of the budget, all of the options that were out there and how we could best position ourselves to get the best outcomes for all of you. I've said this a couple of times. I'm really glad that I work for realtors and not tech companies and not the auto dealers coming out of this session. But it doesn't mean that we don't have to be vigilant for whatever special session there might be this fall or whatever adjustments have to be made next spring based upon what happens with our state budget, our revenues, and our costs. So gentlemen, I don't know if there's anything else that you wanted to chime in on there.
The only thing I would just reiterate is what you said, that there were a lot of kind of third rail tax issues for us on, the agenda this year that we were able to avoid. But, we are not out of the forest yet in terms of these budget issues. So we'll see what happens if a special session gets called this year. And to be honest with you, we still have additional education funding that's going to ramp up as well for the locals in the state. So that will provide more pressure. And, the hope is that the economy grows and provides revenue to, fund some of those costs, but it also makes it harder when we have higher taxes than other states, because corporations obviously look at all of that when they're deciding where to locate businesses. So just stay tuned.
Yeah, I would just add that, Maryland, despite our reputation, in many respects, is actually still quite a business-friendly state. I mean, we still have contributory negligence with one of how many, 3 states left that don't do comparative negligence. We still don't have combined reporting, did not make it into the final bill. And so, there are a lot of reasons to still move your business to Maryland that we just, unfortunately, we know reputations are easy to get and almost impossible to change. And so we do have this reputation as a business unfriendly state. And I think in at least some respects, it's unwarranted, but I think that's the administration's responsibility to fix that. Capital gain surcharge amount, that's actually a good question. Do we have that at the tip of your?
Sure do, yeah, and that was one that we watched. It was in, it was out, it was back in.
Yeah.
So the capital gain surcharge amount, it is 2% on the portion that is capital gains, but there are a couple of caveats. One, this applies when you have over $350,000 in adjusted gross income. So that's a pretty high threshold for most people. And then if your capital gains are from the sale of a primary residence that is valued under $1.5 million, then it does not apply. We do realize if you have a second home, if you have an investment property, and you're claiming a whole lot of capital gains, yes, you could be paying an extra 2% on that portion that is capital gains. We understand that. But having the primary residence in there was a very important consideration that we checked and double checked and triple checked to make sure that remained in the bill.
Well, we still have
Um,
100 people. They seem to be dropping off pretty quickly unless you want to take those last two real quick.
Yeah, absolutely. Question on the mortgage assumption bill. Yes, the people do still have to qualify to assume the mortgage. And we know that sometimes you aren't able to assume the mortgage. You need to either sell the property to give everyone, to divide the assets, or you might have to cash out refi. But if you can afford the mortgage and do all of those things, then you would have the option to assume it under this bill. All right, and then new vehicle fees and taxes go into effect actually July because this is state budget. And do I know the amounts? Let me see. I'm gonna go over here and look. So the vehicle excise tax goes up to 6.5% based upon my my handy cheat sheet here. Tires, when you buy tires for your vehicle, you're gonna pay an extra $5 per tire. Title, when you're titling your car, is going to double. So your new and used vehicle titling fee is going to go to $200. So like I said, very, very quickly, you are making up whatever savings you are finding in the income portion of the budget through user fees.
There we are. All right, thank you, guys. And thanks everybody for sticking in there. We went over the hour, but I think that's really important information, and over 100 of you stayed to the end. So thank you very much, Bill. As always, a pleasure.
Great seeing everybody.
Good to see you, Bill. And just so we can end on a really good note, I just want to mention that our community canvas event is coming up on June 25th with our guest speaker, Leah Rothstein, who you know from Color of Law and Just Action. And then also, if you really wanted to nerd out with me and with Bill and Krista and Jackie on our advocacy team, our Maryland Realtors Committee applications are open right now through, I believe, June 26th.
Right.
So we have a legislative committee, public policy committee, issues mobilization committee, and a host of others that can fit your talents and where you can join us in all of the activities that we do here for Maryland Realtors. So please check those out, both our community canvas event and our committee applications. And again, just thank you so much for being here, for spending your afternoon with us. We greatly appreciate you.
All right, thanks everybody. Take care.
Thank
Thanks, Lisa.
you.
Thanks again, Bill.